Hello friends, welcome you all on my YouTube channel, Decoded. In this video, we will discuss about the LODR amendment, which was notified by the SEBI on 14th of June. So let's discuss one by one. So first of all, I just mentioned that I have included the few key amendment in this, not the whole amendment which was made in the LODR. So let's start with the Regulation 17. So under Regulation 17, what they have done, now they have stopped the permanency of the director on the board of the listed entity. So earlier, suppose if any large shareholders, appoint their director on the board of on the listed entity, no time limit up to which that particular person can be on the board of the listed entity. But now they have put the condition that such appointment shall be approved by the shareholder in the general meeting once in every 5 years. So in this way, they try to stop the permanency of a director. And again, they clarified also that such provision shall not be applicable in case of full-time director, managing director, or manager or independent director, because they automatically cover under the separate provision of the Companies Act, which require the fresh approval after the 5 years of time period or earlier, whichever is given in the amendment has been made in Regulation 27, which is related to the corporate governance requirement. So they have added one new disclosure with respect to cybersecurity incidents, breaches, and the loss of data. So the listed entity has to report the same with the stock exchange. The next is very crucial, which is related to Regulation 30, and this is quite critical because if you remember, as of now, or I would say the extent LODR provision, when you say para B items of Schedule 3, wherein you have to apply the materiality criteria while deciding whether to disclose or not to disclose certain event. So now to stop the discretionary power which lies with the listed entity, they have introduced some quantitative threshold for the judgment for the board of directors. I would say the for the overall listed entity. So now there is no discretionary power, and the way they introduced those materiality criteria in terms of the quantitative numbers. So they have taken the three parameters to decide whether the any event or information is material or not. So first is a 2% of the turnover. The second one is a 2% of the net worth, and the last one is a 5% of the average of absolute value of profit or loss after tax. So the very important terminology is given in the point number 3 when they say absolute. So you have to disregard the plus or minus sign. So you have to pick the value while calculating the 5% of the average uh, profits after tax as per the last 3 years audited consolidated financial statement. So now this requires action. You have to amend your materiality policy, and uh, now there will be more disclosure because now there is no discretion lies with the listed entity. In a similar way, Regulation 30 under sub-regulation 6, earlier there was certain time limit prescribed for 24 hours and board meeting outcomes for 30 minutes. Now they have introduced three different category under which you have to disclose certain disclosable event. So first category is a 30 minutes from the closure of the board meeting in which the decision pertain to the event or information which has been taken. The second category is a 12 hours from the occurrence of the event or information in case the event or information is emanating from within the listed entity. So this is quite important. So if any event or the information emanate from the listed entity itself, so listed entity have only 12 hours criteria, or I would say the limit of the 12 hours to disclose the same to the stock exchange. And the third category they form is 24 hours criteria if the information or the event is not emanating from the listed entity itself. So they have revised this time limits. So the next one is, yes, this is also very critical. Again, earlier there is a provision under Regulation 30, sub-regulation 11, wherein if there is any rumors or information or any event which is reported in the media or the newspaper and widespread in the market, on those information or the event, listed entity may comment or confirm those news to the stock exchange. But now for certain entities this become the mandatory, so they have introduced this provision in a phase manner. So as of now I would say from the October 1st, 2023, top 100 listed entity, mandatorily has to confirm, deny, or clarify any event or information which is, reported in the mainstream media or which is not in the journal in nature or not available to the public. So they have to respond to such kind of news within 24 hours. Criteria is given there. Again, the term mainstream media is defined into the different paragraphs. Like if you read, so it says that the newspaper registered with the Registrar of Newspaper for India. The second category of mainstream media would be news channels permitted by the Ministry of Information and Broadcasting under Government of India. And third one is again content published by the publisher of news, current affairs, content as defined under the Information Technology, Intermediary Guidelines and Digital Media Ethics Rules 2021, and other agencies also included. So first of all, it's like an actionable item could be like, to identify what are the all those mainstream media. So these are the, very broader category or the guiding principle you have to note down, like whether particular news channel or particular newspaper, whether they are governed or not. So you have to make a list, and accordingly for the top 100 listed entity 1st October 23, and for top 250 listed entities April 1st 2024 is the applicability criteria. The next one is insertion. Basically these are new sub-regulation under regulation 30. So now if any event or the information which is disclosable as per regulation 30, and pursuant to that, if you receive any communication from regulatory, statutory, enforcement or judicial authority, so listed entity shall disclose such communication also. And I think this is overkilling, or there would be so much of disclosure in the market, and the genuine investor could not understand or make out what is relevant for them or not. So this is, I would not say it's a good move from the SEBI, but like this is the overkilling, and investor cannot understand the kind of news, noise they will have, and the quality or the main disclosure somewhere lose its relevance, because there would be so much of disclosure from the listed entity by virtue of this new insertion. So the next one is again, this is altogether a new insertion in the regulation itself. There is a regulation 30A which is introduced. So it says that if certain parties enter into an agreement which is specified in clause 5A of para A of part A of schedule 3. So if you remember, schedule 3 divided into the different part. Under part A there are different paragraphs which require the mandatory disclosure, because those events or I would say information are deemed to be material. So clause 5A is a new insertion in this amendment also. So if any agreement specifying those clauses, so those certain parties shall inform the listed entity about the agreement to which the listed entity is not a party within the 2 working days. And subsequently, once the listed entity receive such information from those parties, will disclose to the stock exchange. So we will also read, what kind of agreement mentioned in the clause 5A in the few next slides. And again, there is a new insertion, regulation 31B, which is like special rights to shareholder. So certain entities give special rights to certain shareholders. You can say some large shareholders which have a very like strategically importance to the listed entity, or there could be other aspect. So they listed entity give certain special rights to them, and once they give, so there is no provision as of now which requires the the review, or I would say you can take away those powers. So now SEBI has introduced the criteria of those rights must be approved by the shareholder by way of special resolution once in every 5 years. So if any company as on date having such kind of special rights, so that's required the I guess I would say this is the kind of review mechanism, because shareholder keeps on changing. So it might possible at the earlier instance, shareholder were of a different categories or a different intention, but altogether it might possible after 10 years, the complete chunk of the shareholder get changed, and they definitely review certain certain decision or the items which were approved by the earlier shareholder. So it's quite logical provision, and it should be there. So this is a new insertion. Again, every company has to see what kind of a special right has been given to certain category of the shareholder, and accordingly you have to take the special resolution, pass by the special resolution, or ratify, I would say. So let's move to the next. So now this is the category of Schedule 3, Part A, Para A event. So the first very category of this list is acquisitions related disclosure, scheme of arrangement related disclosure, sale or disposal. Like earlier, there was no mentioning of sale of stake in the associate and the newly incorporated company. So these two words added here, so that these are the extra disclosure. I would say one is a kind of extra disclosure when it comes to sale of stake. So far, the for the newly incorporated company, it's more of a clarification, because there is a confusion as of now. Like because in case of a newly incorporated company, there is no acquisition of share. It's more about the subscription money or the subscriber. The listed entity become a subscriber. So there is a confusion like whether to disclose or not. So now this confusion has been removed by introducing the word to be incorporated. So if listed entity incorporates or involved in the process of incorporation a company, so that require the disclosure, provided that must be falling under the criteria of acquisition. Let's move to the next slides. Then introduction of Para A, which we just discussed earlier slides. So uh, Para A describes certain types of agreement which require to be first disclosed by the certain parties to the listed entity, then listed entity further disclosed to the stock exchange. So the agreement is like, if I would read from the line third, the agreement whose purpose and effect is to impact the management or control of the listed entity, or impose any restriction or create any liability upon the listed entity. So these are the nature of broad category of the nature of the agreement, which requires first level disclosure by certain parties to the listed entity, and the second level disclosure by the listed entity to the stock exchanges. Again, this is quite material information for the investors, and they should know about such kind of agreement or the information. So the next category is related to the fraud or the default related disclosure. This is already there in the regulation 30 part A disclosure, but now they have added the senior management also. So if like any fraud or default done by the senior management, or they have also added the subsidiary word. So if done fraud or default is done by the senior management, again this required disclosure also. And as you know, the list of the senior management might be bit longer than your earlier list of promoter, director, or a KMP. So now it's more about sensitization program within the listed entity to guide their senior management team, or also the subsidiary, that what are the repercussions if fraud or default occurred or listed entity required, because somewhere that such kind of disclosure impact the brand or the image of the company in the market. So then the next is a quite few modification in the insertion. So if I would say para number 7, this is also again earlier, like in the change in the category of the KMP, which includes your managing director and other category company secretary. So they have added the word senior management also in this category. So if you have a point or there is a change in the senior management team, so that's required the disclosure. Then there is a new insertion of para C, wherein uh, this is a new insertion. So in case of resignation, so if there is a resignation of KMP, senior management, compliance officer, director, other than the independent director, so it listed entity has to disclose those resignation with the detailed reason within 7 days. So this is a new insertion. Then para D, uh, which is related to the new provision, and this talks about like if your managing director or CEO are not available to fulfill their duties for more than 45 days, then they have to, the listed entity has to disclose the same fact to the stock exchange with reason. Para 15, this is related to schedulement of analyst or the institutional investor meet. So earlier there was no time limit prescribed for giving the intimation. Now they have introduced the 2 days criteria in advance, which exclude the date of intimation as well as the date of meet. So it's like pure or clear 2 days intimation required. A similar kind of disclosure also be there on the website of the company. Then the new insertion, which is related to para 18. So if any communication or the announcement done through the social media intermediaries or the mainstream media by directors, promoters, KMP, or the senior management folk of the listed entity, that or which is quite, the material information as per regulation 30, or not readily available, already available in the market. So that's also required the disclosure, so that there is no information asymmetry in the market. Then the next one is para 19. Again, it's a new insertion. I would say para 19 and para 20 is a similar set of a similar disclosure, but in para 19 they have specifically include certain events. So like if I would say, if there is any action or orders in the nature of search and seizure, reopening of accounts, this is related to para 19 that require the disclosure. And in the para 20, if action or the order pass related to suspension, imposition of penalty, fine, settlement of proceeding, debarment, disqualification, closure of the operation, sanction imposed, warning, caution, or any other similar action which is, related to the above category, that require the disclosure. Let's move to the last slides. These disclosure related to para B, which should be judged or determined on the basis of the materiality threshold. So there is a sub para 2, wherein they club the earlier 2 category, if I would say. So these are related to, arrangement for the strategic, technical, manufacturing, marketing tie-ups, adoption of the new line of business, or the closure of the business unit or division or subsidiary in entirety or the piecemeal. So this require, again, you have to check the materiality threshold while disclosing these events. Then the next one is a sub para 5, which is related to agreement, loan, or any other agreement which are binding and not in the normal course of the business. So earlier the word used is borrower. So if you are borrower, then you supposed to be disclose such kind of agreement, but now they remove the word borrower. So the implication of this, whether you are lender or the borrower, you have to disclose this event depending on the materiality threshold. Then in subpara 8, it was again earlier it was there in the LODR, but now they have added the word pendency. So if pendency of any litigation, dispute, or outcome of which may affect the listed entity, that require the disclosure. Then under subpara 9, this is related to the fraud or default related disclosure by the directors of the KMP. Now they have added the word employee. So like everyone, may or like cover under such kind of fraud or the defaults by the employees of the listed entity. It's like a very larger implication. It's again is sensitization program within listed entity. Then there is a new insertion of subpara 3, wherein if the listed entity delay or default in making a payment of fines, penalties, or dues to any regulatory, statutory, enforcement, or judicial authority that requires the disclosure. And last 2 is related to the annual report. So they have introduced the one separate section in the annual report section, wherein you have to provide the details of the senior management, including the changes therein, and which again one more para added in the schedule 5, which talks about agreements mentioned under clause para A of schedule 3, which we just discussed earlier. So the reference or some details of the salient feature of such agreement must be there in the annual report. So this is all about the key amendment which were made by the SEBI in the recent LODR amendment dated 14 June 2023. I hope this this video might be useful for you. Thank you so much.